1522. The record should reflect that Mr. Holmes is present with his attorneys, Ms. Brady, Mr. King, Ms. Higgs, Ms. Spengler, and Ms. Nelson, and the people are represented by Mr. Brockler, Mr. Orman, Ms. Pearson, Mr. Edson, Ms. Stitch McGuire, and Mr. Edwards. And we're outside the presence of the jury. The record should reflect that my staff emailed the parties the final set of jury instructions and the sample verdict form that I intend to give the jurors. Is there any other record that the people want to make with respect to instructions, or are there any other instructions that the people wish to tender?
No, sir, thank you.
Okay, same question, Mr. Brockler, with respect to verdict forms. Any other record, including objections or any other forms to tender?
None, Your Honor.
All right, thank you. Ms. Brady, same questions for you. Any other record that you want to make with respect to instructions, including any additional objections, any additional arguments, or any additional requests?
No, sir.
And any additional record that you want to make with respect to verdict forms?
No, sir.
Okay, thank you. All right, are the parties ready for the jury?
Yes.
We are, Your Honor. I just want to put on the record, I'm going to print this, and while the court's going through the instructions, I'll have a copy given to Ms. Brady's team to give to her, and hopefully we'll be able to review it during the instructions.
Okay, thank you. Remember that I limited you to 40 minutes. Do you want a warning, a time warning? Ms. Brady, do you want one?
I've asked Mr. Lange to give me a warning that I have 5 minutes.
Okay, great. Mr. Brockler?
Your Honor, I'd ask for 25 minutes and at 35 minutes.
25 minutes and 35 minutes. That'll cost you extra. Okay, let's bring the jury in, please. Please be seated, everyone. The record should reflect that the jury is now back in the courtroom. Welcome back, folks. How's everyone doing? Good. I see you're back to your usual seats. That must mean that some of you are feeling better, or perhaps the rest of you are feeling more courageous and risky. Thank you for your patience this morning. As you know, there are times when the lawyers and I have to get some work done outside your presence, and we've been working hard. We tried to start when I told you that we would start, which was about 11:30, and we ran a little late, but I appreciate how patient you've been today and throughout. At the end of the day yesterday, the defense had called a witness, and so let me now ask Ms. Brady if there is additional evidence the defense wishes to present.
No, thank you, Your Honor.
All right, thank you. Mr. Brockler, do the people wish to present rebuttal evidence?
No, sir, we do not.
All right, thank you. Folks, that means that the evidence has now been completed in phase 2 of the sentencing hearing, and so I'm going to have my staff distribute to you a copy of the jury instructions, and each of you will get your own copy. Remember that I have the original set here. Mine is stamped original. Your copies are stamped copy. You can make any notations or markings on your copy. Please do not make any markings or notations on the original. And then we're also going to distribute a sample verdict form. You can make any notations that you wish on the sample verdict form. I have the original verdict forms here, and you should not make any markings on the verdict forms except to indicate your verdicts. Does everyone have a copy of the instructions in the sample verdict form? Yes, okay. Everyone's nodding their head or saying yes.
Judge, I'm sorry
Yes.
to interrupt. May we approach
Yes,
this?
go ahead. Members of the jury, before we start, there is a page that's missing. It's only about 5 lines. But what we're going to do is have my staff print a bunch of copies of that one page, and then we'll have each of you insert it into your instructions, and I'll insert it into the original instructions as well, okay? So if you give us a moment, please. Thank you. While we're doing that, let me remind you that after I read the instructions and I go over the sample verdict form, we will take a break, probably a 20-minute break, and then at that point we'll proceed with the closing arguments. I have given each side 40 minutes. The defense will go first, the prosecution will go next. And as I said, each side gets 40 minutes. And then after that, the 12 jurors who are the deliberating jurors will start deliberating. The alternate jurors, you know the drill, will have to separate you and put you in a different room so that you don't have any contact with the deliberating jurors. And in terms of the alternate jurors, the same admonishments will apply, except that you cannot deliberate. Even in your own minds, you cannot start forming opinions or thinking about the case or deliberate at all. The alternates will be in a room separate from the deliberating jurors. And then we'll use room 201 again as the deliberating jury room. We will send back all the exhibits with the exception of live ammunition. And if you at any point want to see the live ammunition, you can send us a note, send me a note, and you know how to do that through the foreperson. What we'll do then is give you the live ammunition and take back any weapons, any firearms that you may have in the jury room. The other thing that I should tell you about is there will be a short wait period, if you will, of a couple of hours once the jury has reached its verdict. So it'll be 2 hours between the time when the jury reaches its verdicts and the time when I announce them in the courtroom. That's to give everyone a chance to get here to the courtroom and to attend. Does everyone understand that? Okay, and so please plan ahead. Now, the deliberating jurors set their own hours, and I think in the past, the foreperson has indicated that from now on, the deliberating hours will be 8:30 to 4:30, I believe, and that's fine. But if at any time you want to change that, just let us know so that we can coordinate with the alternate jurors, okay? Ms. Zagel, do you have those? Great, perfect timing. Can I see that, please? Perfect, thank you. All right, would you please distribute this? Give counsel their copy first and give him a chance. Actually, can I have one? I didn't take one. I need one. Thank you. Give the counsel their copies first, please. And then let's make sure that they're all in agreement that that's the page that's missing. Does that look right, Mr. Orman and Ms. Nelson?
Right to me, Your Honor.
Okay, Ms. Nelson? Great, thank you. Now, because my set's not stapled, it's like nothing wrong ever happened. So, but with respect to your copies, you may need to just stick it in there, and I can have my staff restaple those for you during the break if you wish, okay? All right, would you distribute that page, please? And I'll tell you where that page goes. That page goes in instruction number 4. At the end, it's the last page of instruction number 4. So right before instruction number 5. Does everybody see that? Okay. I'll give you a moment to get there and to include it in the right place. I'm going to blame the copy machine, by the way. Did everybody find the place? It looks like a couple of you are still looking. There we go. All right, everyone ready? Okay, I'm going to read these verbatim and ask you to follow along as I'm reading them to you. Jury instructions, phase 2 of sentencing hearing. Instruction numbers 1 through 22 given by the court this 30th day of July of 2015. Sentencing hearing, phase 2, instruction number 1. Members of the jury, phase 2 of the sentencing hearing has been completed. During the course of the trial and phases 1 and 2 of the sentencing hearing, you have received all of the evidence that you may properly consider in reaching your phase 2 sentencing verdicts. In a moment, I will read to you jury instructions that contain the rules of law you must apply to reach your phase 2 sentencing verdicts. You will have copies of what I read to take with you to the jury room. But first, I want to mention some things you need to keep in mind when you are discussing this case in the jury room. In these instructions, I refer to the first part of the proceedings as the trial, and to the present part of the proceedings as the sentencing hearing, or more specifically, as phase 2 of the sentencing hearing. If I refer to the proceedings, I am referring to the trial and phases 1 and 2 of the sentencing hearing. Until you have returned your phase 2 sentencing verdicts, you must follow all of the following admonishments. You must reach your phase 2 sentencing verdicts based only on the evidence presented in the courtroom and the instructions provided by the court. This includes all of the evidence presented during the trial. However, to the extent that I tell you that you may only consider certain evidence for a limited purpose, you must only consider such evidence for the limited purpose that I tell you it may be considered. Do not communicate about the case with anyone else in any way, including in person, by telephone, cell phone, smartphone, iPhone, BlackBerry, computer, the internet, or any internet service. This means that you must not email, text, instant message, tweet, blog, or post information about this case or about your experience as a juror in this case on any website, listserv, chat room, blog, or website such as Facebook, MySpace, LinkedIn, YouTube, or Twitter. You must not communicate in any way with anyone else about this case or this kind of case. This includes your family members and friends. You must not read, review, or accept any communication in any form from anyone regarding this case or a case like this one. All you can tell family members, friends, acquaintances, and strangers is that you're on a jury in Arapahoe County that is anticipated to be completed at the latest by the end of August. If you notice that people are discussing the case, remove yourself from that location immediately. Do not attempt to gather any information on your own about this case or any case like it. You must not read or conduct any research about this case or this kind of case using any source, including dictionaries, reference materials, the internet, or any other electronic means. Many of us routinely use the internet to research topics of interest, but you may not do that in relation to this case. You may not use Google, Bing, Yahoo, or any other type of internet search engine to learn about any person, place, or thing that is involved in this case. This includes the defendant, the attorneys, the witnesses, your fellow jurors, court personnel, and me. This applies whether you're here at home or anywhere else. Do not read about this case or any case like it in the newspapers or on the internet. Do not listen to any radio broadcasts about the case or any case like it. And do not watch any television news reports regarding the case or any case like it. Do not attempt to visit any places mentioned in this case. Do not in any other way learn about this case or this kind of case outside the courtroom. Do not talk to the witnesses, parties, and attorneys about anything. Do not talk to any members of the media about anything. Do not have any contact through any means, including in person, by telephone, text, or email, with any jurors who have been discharged. You also should not have any contact through any means, including in person, by telephone, text, or email, with any of the alternate jurors. Make sure that you wear your juror badge whenever you're on the courthouse grounds and that your juror badge is visible to those around you. If you have a cell phone or other electronic device, you must temporarily surrender it to my staff. You're not allowed to have a cell phone or other electronic device in the jury room during your deliberations. You will get your electronic devices at the end of the day before you go home. Lastly, although you may start deliberating when I tell you that you may do so, you may discuss this case only when you're all present and only when you're in the jury room. No juror should attempt to discuss this case with another juror or other jurors except when all the jurors are present in the jury room. All deliberations must occur in the jury room when all 12 jurors are present. It is my job to decide what rules of law apply to the case. While the attorneys may comment on some of these rules, you must follow the instructions I give you. Even if you disagree with or do not understand the reasons for some of the rules of law, you must follow them. No single instruction describes all the law which must be applied. The instructions must be considered together as a whole. Your Phase 2 sentencing verdicts are not dictated by law. Rather, in this phase of the sentencing hearing, each of you will be called upon to deliberate, to make decisions based on your individual reasoned moral judgment. None of your earlier decisions in these proceedings dictates what your Phase 2 sentencing verdict should be with respect to each count of murder in the first degree. At times during the proceedings, the attorneys have made objections. Do not draw any conclusions from the objections or from my rulings on the objections. These only related to the legal questions that I had to decide and should not influence your thinking. If I told you not to consider a particular statement that was made during the proceedings, you must not consider it in your deliberations. Similarly, if, during the proceedings, I sustain an objection to a question after a witness had already provided an answer or partial answer, you must not consider any part of that answer in your deliberations. I may have asked questions of witnesses during the proceedings. That did not mean that I had any opinion about the facts in the case. Remarks and rulings I have made during the proceedings should not be understood by you as suggesting any opinion or feeling on my part as to what has or has not been proven in this case. Further, remarks and rulings I have made during the proceedings should not be understood by you as suggesting any opinion or feeling on my part as to what Phase 2 sentencing verdicts you should reach. I remind you that I'm neutral in these proceedings. Sentencing hearing Phase 2 instruction number 2. A mitigating factor is not a justification or excuse for the crime. Rather, a mitigating factor is a fact or circumstance which, in fairness or mercy, may be considered as extenuating or reducing the degree of the defendant's moral culpability or as diminishing the appropriateness of a death sentence. Thus, mitigation refers to anything about a person or his offenses that weighs in favor of a life sentence for any juror. Mitigation can include facts or circumstances about the crimes for which the defendant has been found guilty, but mitigation is not restricted to the events or circumstances related to the defendant's crimes. Indeed, mitigation does not need to have a link or connection to the defendant's crimes. Mitigation can also include facts or circumstances that bear on the defendant's moral culpability. Thus, mitigation can include, but is not limited to, a broad range of factors relating to the defendant's personal history, character, background, and mental health. Mitigation is also not limited to evidence presented by the defense. Evidence of mitigation can come from any source and can be presented by either party. A juror may find a mitigating fact or circumstance in the evidence even if it has not been specifically called to his or her attention by the parties. Likewise, a juror may consider as mitigation any evidence that he or she finds to have mitigating value, even if such evidence has not been specifically presented or argued as mitigation. Therefore, any list of mitigating factors mentioned in the instructions that follow cannot and does not limit your determinations about mitigation. The mitigating factors referenced in the instructions that follow are examples of mitigation you may consider in reaching your Phase 2 sentencing verdicts. While you should pay careful attention to these mitigating factors, you're not restricted by them. The court instructs you that you may not in any fashion consider any mitigating factor as an aggravating factor, nor may you ever consider a mitigating factor as a reason in favor of a death sentence. Sentencing hearing Phase 2 instruction number 3. The following is a list of mitigating factors defined by statute that the defendant has asserted in Phase 2 of the sentencing hearing. 1. The age of the defendant at the time of the crime. 2. The defendant's capacity to appreciate wrongfulness of the defendant's conduct or to conform the defendant's conduct to the requirements of law was significantly impaired, but not so impaired as to constitute a defense to prosecution. 3. The emotional state of the defendant at the time the crime was committed. 4. The absence of any significant prior conviction. 5. The extent of the defendant's cooperation with law enforcement officers or agencies. And 6. Any other evidence introduced that bears on the question of mitigation. You may not in any fashion consider any of these types of factors as aggravation or reasons in favor of a death sentence. Sentencing hearing phase 2, instruction number 4. This is the defendant's theory of mitigation instruction. In addition to the mitigating factors listed in the previous instruction, you must consider any mitigating factors listed in this instruction which you, as individual jurors, decide exist as reasons for a life sentence over a death sentence. You may not in any fashion consider these factors as reasons in favor of a death sentence. You should not take this instruction to mean that the court regards the facts below as established, or, if established, that they necessarily must be viewed by you as mitigation. It is for you to decide whether the facts asserted by the defendant as mitigation are established, and, if so, whether they are to be regarded as mitigating factors. Number 1, all of the experts who have evaluated Mr. Holmes in this case agree that regardless of his specific diagnosis, Mr. Holmes suffers from a chronic and serious mental illness and a schizophrenia spectrum of disorders. Number 2, all of the experts in this case agree that Mr. Holmes is not malingering or faking his mental illness. Number 3, this chronic and serious mental illness was the cause of the events of July 20, 2012. Without this mental illness, and if Mr. Holmes' mind had remained healthy, these crimes would never have taken place. Number 4, Mr. Holmes was genetically loaded to develop a psychotic disorder. There's a history of significant mental illness on both sides of Mr. Holmes' family. Mr. Holmes' maternal grandfather suffered from a psychotic illness and was hospitalized. Mr. Holmes' paternal grandfather also suffered from a severe and disabling mental illness that required hospitalization. Mr. Holmes' aunt, Betty Holmes, the twin sister of his father, Robert Holmes, has schizoaffective disorder, which is the same illness with which Dr. Jeffrey Metzner and Dr. Jonathan Woodcock have diagnosed Mr. Holmes. Betty Holmes has been disabled from this disease since the age of 19. Betty Holmes has been hospitalized 4 times in a psychiatric hospital for auditory hallucinations, psychotic symptoms, and suicidal ideation. She's been on psychiatric medication since 1983. Number 5, Mr. Holmes was 24 years old on July 20, 2012. Colorado law states that the age of the defendant is a mitigating factor. Mr. Holmes' age of 24 falls within the age range during which males most frequently experience the onset of schizophrenia and related illnesses such as schizoaffective disorder. Number 6, prior to the events of July 20, 2012, Mr. Holmes had never been arrested or convicted of a crime. Number 7, as a young boy, Mr. Holmes moved to the Salinas, California area and lived in a family-oriented neighborhood called Oak Hills. Mr. Holmes grew up in a loving home with his mother, Arlene, his father, Bob, and his younger sister, Chris. By all accounts, Bob and Arlene were caring, involved, and concerned parents. Mr. Holmes was loved and supported by his parents throughout his life, and they continue to love and support him. Number 8, friends and neighbors from Oak Hills described Mr. Holmes, whom they knew as Jimmy, as good kid who was sweet, a gentleman, and never exhibited any sort of problem behavior. They never saw him be rude or disrespectful. Mr. Holmes was part of a group of boys who played together in the neighborhood. He got along well with the other kids and was accepted into their group. He was fun to be around and was a good friend. He mediated conflict and did not initiate it. He appeared to be a happy child to those who knew him. Mr. Holmes' parents described this as the happiest time of his life and described him as a social and affectionate child. Number 9, Mr. Holmes participated in typical activities for an elementary school-aged child. He took piano lessons, and his piano teacher described him as a sweet boy who she enjoyed teaching. He participated in recitals and practiced to improve his skills. Mr. Holmes also began playing competitive group sports and enjoyed playing soccer, basketball, and taekwondo. Number 10, Mr. Holmes' younger sister, Chris, was born when he was 5 years old. Mr. Holmes was excited to have a little sister and took a big sibling class at a local hospital to prepare to become a big brother. Mr. Holmes was gentle with Chris as a baby and was a kind and patient big brother. He loved his sister very much and she loved him. Mr. Holmes' sister continues to love and support her older brother. Number 11, Castroville Elementary School teachers described Mr. Holmes as a bright child who had high academic ability and was responsible and well-liked by the other students. He received awards regularly. Teachers and administrators never observed him being rude or mean to other students. To the contrary, Mr. Holmes served as an example to other children during this time in his life. Mr. Holmes' teachers cared about him and continue to care about him. Number 12, Mr. Holmes loved animals and was good with them. He walked and bathed them and liked to pet and cuddle them, and wrote of his sadness in his journal when his dog Zuby died. Number 13, the Holmes family moved to the Rancho Panasquitos neighborhood of San Diego 2 weeks before the end of 6th grade. The move was difficult for Mr. Holmes. Once active and outgoing, beginning with middle school, Mr. Holmes became more subdued and often preferred to stay in his own room or play video games on the computer. His mother attempted to assist him in making friends with the other neighborhood boys, but he did not make friends as easily as he once did. Mrs. Holmes described her son around this time as not as exuberantly joyful as he once was. Not as exuberantly joyful as he once was. While Mr. Holmes' increasing isolation and withdrawn behavior coincided with the move, they were in fact early symptoms of his mental illness that occurred during what is known as the prodromal phase of schizophrenia and related illnesses such as schizoaffective disorder. Number 14, in 2001, when Mr. Holmes was 14, his parents sought family counseling from a social worker named Mel Lipsey, in part out of concern that their son did not seem happy and had trouble making friends. Number 15, unbeknownst to anyone else at the time, Mr. Holmes began having unwanted homicidal thoughts in middle school. These thoughts were also prodromal symptoms of his mental illness. It was around this time that Mr. Holmes began to believe that his mind was broken. However, as he told Dr. Reed, he did not share what was happening internally with anyone because he did not want to appear weak or be a burden to his family. As Arlene Holmes testified, the Holmes' family culture was to be stoic, not to complain, to be grateful, responsible, and strong, not weak. Number 16, Mr. Holmes still excelled academically at Mesa Verde Middle School and joined the band and played trumpet for both 7th and 8th grade. He also played soccer. He never caused any trouble in his classes and got an outstanding citizenship grade. Number 17, by the time he entered Westview High School, Mr. Holmes worked hard to avoid attention. His high school teachers described Mr. Holmes as a quiet, good student who was a by himself kind of guy who was pretty invisible in class and never did anything to stand out. No one ever complained about Mr. Holmes being mean or disrespectful. He never got in trouble, and teachers have no negative memories of him at all. Still, he did not seem like a happy teenager to his teachers. He joined the cross-country team, but never talked to anyone and was not part of the group. His mother describes picking him up once and observing him staring off into space. His cross-country coach, Lori Godwin, described him as a shadow-type figure. He was always on the outside and stood out to her as different. As a special education teacher, Ms. Godwin's observation of Mr. Holmes' behavior made her wonder whether he had a learning disability. He appeared extremely anxious and uncomfortable when spoken to. He was quieter than even the quietest kids, and even had trouble being close enough to people to participate in the team yearbook photo. Ms. Godwin never saw him smile, yet he consistently showed up to practice. Mr. Holmes was not a particularly good runner, but he never reacted badly to losing. He was never a problem boy, never bullied anyone, and was never violent. These behaviors Mr. Holmes exhibited in high school were more early prodromal negative symptoms of Mr. Holmes' mental illness. Number 18, Mr. Holmes played soccer throughout junior high and high school. Former teammate Patrick Silva remembers him as a very sweet, quiet kid who flew under the radar and didn't cause a lot of trouble. Mr. Silva remembers Mr. Holmes as being a great team player who was never mean to anyone. Number 19, during this time in his life, despite the presence of unwanted homicidal thoughts, an increasing amount of social anxiety, difficulty speaking and interacting with others, and other prodromal symptoms of his illness that others mistook for mere shyness and awkwardness, Mr. Holmes strived to be a good student, son, brother, friend, and neighbor. He was a kid who wanted to please everyone. Number 20, Mr. Holmes was baptized at Rancho Bernardo Community Presbyterian Church in 1994. Growing up, Mr. Holmes attended church with his family at the Penasquitos Lutheran Church and became a member in 2012. He participated in the annual church cleanup with his family and volunteered to work with youth during the Cross of Victory Celebration Week. Number 21, Mr. Holmes was the type of young person who helped his family and friends. He helped his Uncle Dexter with gardening. He took care of neighbor Barbara Martin's pets and helped her with a landscaping project. He helped an elderly woman in the neighborhood by picking up groceries for her and taking out the trash, and volunteered at the Red Cross. Miss Martin, the neighbor, recalls Mr. Holmes as pretty much a model child. Number 22. During his undergraduate years at the University of California at Riverside, Mr. Holmes continued to keep to himself. He eventually engaged in social gatherings that others in the honors dorm participated in, but only after receiving much encouragement. He continued to be very studious and excelled academically. Arlene Holmes described her son as very studious, self-motivated, and independent. 23. College friends never recall him being mean or disrespectful. College friend Ryan Lacroix described him as fairly passive. Earl Domingo likewise described Mr. Holmes as very mellow. Soren Carr characterized him as introverted and easygoing. These friends continue to support Mr. Holmes. 24. In the summer of 2008, while he was an undergraduate, Mr. Holmes worked as a camp counselor at Camp Max Strauss in Glendale, California. The camp was a sleepaway camp for inner-city children ages 7 through 12, many of whom were emotionally disturbed. Camp counselors remember Mr. Holmes as reserved and shy, but good with the kids. The other counselors never saw Mr. Holmes act frustrated or upset with any of the campers. Children liked Mr. Holmes and tended to gravitate toward him. Number 25, during college, Mr. Holmes also took a number of bus trips to orphanages in Tijuana, Mexico through an organization called Corazón de Vida. Mr. Holmes took these trips once every 3 months and participated in bringing supplies to the children there, played with them, and made meals for them. Number 26, in the fall of his senior year of college in 2009, Mr. Holmes applied to a number of graduate schools. Despite having stellar academic credentials, he was not accepted, and upon graduating in the spring of 2010 at the age of 22, he moved back home to San Diego, where he slept, watched television, and played video games for months. This lack of motivation was another prodromal negative symptom of Mr. Holmes' illness. 27. In October 2010, his mother became frustrated with his lack of motivation and told him to get a job. Mr. Holmes obtained a job through a temp agency at Marical, a pill coating factory in Orange, California. Co-workers described Mr. Holmes as to himself and not social at all during this time period. He was never rude or disrespectful to the other employees there, but communicated with short one-word answers to questions. Tara Fournier testified that Mr. Holmes reminded her of her children who have Asperger's syndrome and autism and described them as in another place. Jose Sanchez Lopez testified that he once observed Mr. Holmes staring at the wall like someone was talking to him. 28. Mr. Holmes applied to graduate schools for a second time in the fall of 2010. This time, he was granted interviews at several schools and was accepted. Perceived him as awkward and difficult to engage in social interaction. They described Mr. Holmes as making great effort to avoid social interaction with them, and he would often leave class immediately to avoid sharing elevators with fellow students. These behaviors were the signs of increasingly prominent negative symptoms as Mr. Holmes' mental illness progressed. However, the signs were largely missed by the people who knew him in the graduate program, most of whom had only met him recently and had limited interaction with him that revolved around school. These individuals perceived the defendant's awkwardness and shyness as characteristics that were not uncommon for scientists. Number 30. Mr. Holmes' mental illness began to worsen during the winter of 2011 and spring of 2012. His girlfriend broke up with him, and Mr. Holmes began to experience an increase in homicidal thoughts and feelings of depression and worthlessness. In early 2012, these thoughts began to develop into a delusional belief that he could increase his self-worth by gaining human capital and killing people. This thought process, as well as the contents of Mr. Holmes's thoughts, were not the product of a healthy mind. Number 31, Mr. Holmes expressed these delusional beliefs for the first time in a Gmail chat with his former girlfriend in late March of 2012. Number 32, in mid-March 2012, Mr. Holmes sought help from Student Mental Health Services. He spoke with a social worker named Margaret Roth and immediately volunteered that he was having thoughts of killing people. Ms. Roth referred Mr. Holmes to Dr. Lynn Fenton, and told Dr. Fenton that Mr. Holmes was one of the most anxious patients she had ever seen. Number 33, Dr. Fenton first met with Mr. Holmes on March 21, 2012. Mr. Holmes volunteered to her during this first visit that he was having thoughts of killing people. Dr. Fenton suspected during her first meeting with Mr. Holmes that he had psychotic level thinking. Number 34, after this first visit, Dr. Fenton sent Mr. Holmes home to his apartment where he lived alone with a prescription of sertraline and SSRI for Mr. Holmes's reported anxiety. An SSRI can cause an individual who has a mental illness with a bipolar component such as schizoaffective disorder to experience mania. Dr. Jeffrey Metzner has diagnosed Mr. Holmes with schizoaffective disorder. Mr. Holmes reported in his notebook and later to psychiatrists that he experienced manic symptoms while on the sertraline. Dr. Metzner testified that while the sertraline did not cause Mr. Holmes' mental illness or delusional thinking, the sertraline could have contributed to an increase in Mr. Holmes' symptoms. Dr. Fenton increased Mr. Holmes' dosage of sertraline several times during the course of her treatment. Number 35. Mr. Holmes attended a total of 7 sessions with Dr. Fenton between the months of March 2012 and June 2012. He always came to his appointments and never disavowed his homicidal thinking, although he denied specific plans or targets. Mr. Holmes later expressed ambivalence about wanting help for his delusional thinking. On the one hand, he wanted to be stopped, yet on the other hand, he wanted help and treatment. This type of ambivalence is often part of the psychotic process, and it can be difficult for people with psychotic illnesses to voluntarily seek help and participate fully in the treatment process. Number 36, according to Dr. Fenton, over the course of these months, Mr. Holmes' mental health was in decline. Her notes reflect that she repeatedly suspected psychosis. Following her last meeting with Mr. Holmes on June 11 of 2012, Dr. Fenton's notes expressed significant worries about the dangerousness of this student. She observed that Mr. Holmes is intermittently functioning at a psychotic level and questioned whether he was shifting insidiously into a frank psychotic disorder such as schizophrenia. She noted that Mr. Holmes' attitude was evasive, guarded, hostile, suspicious, and uncooperative. She noted that his affect was inappropriate, odd, and bizarre, and that his thought content contained paranoid delusions and preoccupation. She noted that he glanced around the room in an odd way. She testified that she thought some of the odd statements he made were perhaps a reflection of disorganized thinking. Dr. Fenton became so concerned about his homicidal thoughts that she asked her superior, Dr. Robert Feinstein, to attend several of her sessions with Mr. Holmes to consult. 37. Dr. Feinstein testified that his primary concern was that Mr. Holmes was in the throes of a psychotic episode. Number 38. There's a statute in Colorado that authorizes mental health providers to involuntarily hospitalize a person for 72 hours if the person appears to have a mental illness and, as a result of such mental illness, appears to be an imminent danger to himself or others, or appears to be gravely disabled. Dr. Fenton chose not to voluntarily hospitalize Mr. Holmes, in part because he denied having specific plan or target. Number 39. Dr. Fenton also called Mr. Holmes' mother Arlene without his permission. Dr. Fenton's primary concern was Mr. Holmes' potential dangerousness. However, she never told Mr. Holmes that her son was having homicidal thoughts 3 to 4 times a day. Nor did Dr. Fenton ask Mr. Holmes' mother whether she was aware of Mr. Holmes having any sort of homicidal thoughts in the past. Mrs. Holmes told Dr. Fenton that her son had always been very shy and socially awkward and had some social anxiety. The Holmeses later attempted to follow up with Dr. Fenton and left a voicemail for her expressing concern that her son may have Asperger's syndrome, but Dr. Fenton never returned their call. Number 40. During the months Mr. Holmes was in treatment with Dr. Fenton, his delusional psychotic thinking began to intensify and his illness worsened. Mr. Holmes cut himself off from his friends, stopped studying, and, despite no prior interest in weapons, guns, or violence whatsoever, began amassing startling quantities of firearms, ammunition, and other gear, and began frequenting a shooting range. He built improvised explosive devices in his apartment, dyed his hair orange, signed up for motorcycle lessons, joined adult dating websites with the tagline, "Will you visit me in prison?" All of this behavior was completely out of character for the person Mr. Holmes had been his entire life and was fueled by his psychotic delusional thinking born of his mental illness. Number 41. During this time, Mr. Holmes also began writing the notebook he ultimately mailed to his psychiatrist. The notebook not only contains Mr. Holmes's plans to commit the theater shooting, it exhibits psychotic thinking and expresses many bizarre concepts. Mr. Holmes's mind became dominated by psychotic thoughts of life, death, purpose, value, and worth. In the notebook, Mr. Holmes also describes all of the symptoms of his broken mind and explains that he made it his sole conviction to try to fix his broken mind, but using something that's broken to fix itself proved insurmountable. Number 42. At earlier points during the course of his mental illness, Mr. Holmes was able to use coping mechanisms to manage the symptoms he was experiencing. As his mental illness worsened and his delusional beliefs began to overwhelm him, he was unable to successfully keep them at bay. In Mr. Holmes's final text messages to Hillary Allen on July 8, 2012, he told her that he believed that he was experiencing dysphoric mania. He told Ms. Allen that while his condition used to be manageable, it was floodgates open now. Number 43. Immediately after the shooting, Mr. Holmes did not resist arrest and was cooperative with police. Mr. Holmes told the officers at the scene, truthfully, that he was the only person involved in committing the shooting and voluntarily disclosed that he had improvised explosive devices at his apartment. Number 44. In the interrogation room at the jail, Mr. Holmes engaged in odd behaviors consistent with mental illness and psychosis. He manically fidgeted under the table and then became still and stared off blankly into space for long periods of time. He appears disoriented at times. When jail staff came into the room to bag Mr. Holmes's hands, Mr. Holmes asked if the paper bags are because of, but didn't complete the sentence. When the staff asked him what he thought the bags were for, he stated that he was asking staff what they were for. The staff asked him what, and Mr. Holmes responded, what? Jail staff asked him, huh? And Mr. Holmes repeated, huh? This behavior is consistent with echolalia, a meaningless repetition of another person's spoken words that are a symptom of a psychiatric disorder. The staff then asked Mr. Holmes again what he believed the bags were for, and Mr. Holmes responded, popcorn? Mr. Holmes then began to make rhythmic noises with the paper bags on his hands. This bizarre behavior is consistent with a person suffering from psychosis. Number 45. Mr. Holmes was subsequently interviewed by law enforcement about the devices in his apartment. Mr. Holmes gave the police accurate information and answered every question that was asked of him. He made no attempt to mislead law enforcement. He asked for nothing in exchange for this information and received nothing in exchange for this information. Number 46. Mr. Holmes remained psychotic in the jail between July and November 2012. He wrote the Galactic Colonization writings during this time period, which exhibit psychotic thinking. Number 47. In November 2012, while he was in the custody of the Arapahoe County Jail, Mr. Holmes became floridly psychotic. He stood on his bed and appeared to fall backwards onto the floor of his cell and was non-responsive at first to the deputies who responded to the fall. Soon thereafter, Mr. Holmes was moved to a cell in the Behavioral Control Unit for his own safety and was put in a suicide gown. Mr. Holmes began exhibiting increasingly bizarre and disorganized behavior, including lying naked and catatonic in a frozen position on the floor on his stomach with his arms twisted up and his legs bent up in the air, smearing feces, licking the walls, speaking gibberish, eating paper cups, and attempting to do a backward somersault with a cup on his penis. He seemed disoriented, confused, and at times fearful and emotional. He was eventually moved to a different cell because his room was full of feces. He was unresponsive when deputies tried to move him, so he was dragged to another cell on a blanket. Number 48. Mr. Holmes was ultimately transported to Denver Health Medical Center. Paramedics observed that he appeared flat, disheveled, and parched. In the ambulance, he was unable to hold a conversation. After he was asked to repeat the phrase, "You can't teach an old dog new tricks," once, Mr. Holmes continued to repeat this phrase for an hour and a half, exhibiting echolalia. Number 49, every doctor who came into contact with Mr. Holmes at Denver Health Medical Center was of the opinion that he was suffering from psychosis and delirium. The delirium was caused by Mr. Holmes' refusal to eat and drink in the jail because he believed his food was being poisoned. In other words, Mr. Holmes' paranoid psychosis precipitated his delirium, not the other way around. Number 50, DHMC staff observed that Mr. Holmes exhibited many signs and symptoms consistent with psychosis, including catatonia, disorganized and nonsensical speech, and experiencing auditory hallucinations and visual hallucinations. Mr. Holmes told Dr. Philippe Weintraub that he had been seeing shadows at night. The video footage of the security camera in the hospital room shows Mr. Holmes fitfully trying to hide under blankets while in restraints in his hospital bed at night. Number 51, Mr. Holmes was administered the antipsychotic medication Haldol, which was switched to risperidone shortly thereafter. Mr. Holmes' condition improved with the antipsychotic medication, and there was less suffering for him. Mr. Holmes remains on the antipsychotic risperidone to this day. Antipsychotic medication primarily treats positive symptoms of schizophrenia and related illnesses such as schizoaffective disorder, although delusions are more difficult to treat. It does not impact negative symptoms, and it is not a cure for schizophrenia or schizoaffective disorder. Number 52, Mr. Holmes acknowledges that he needs his medications and continues to take them regularly as prescribed and without opposition or incident. Mr. Holmes has expressed that the medications he is taking help him manage his psychotic and depressive symptoms. Number 53, schizophrenia and related disorders such as schizoaffective disorder are debilitating, lifelong brain diseases. There is no cure for schizophrenia or schizoaffective disorder. Schizophrenia and schizoaffective disorder in general are characterized by progressive changes in the brain and a decline in functioning over time. Number 54. Experts in this case have identified statistically significant changes in Mr. Holmes' brain consistent with those found in individuals diagnosed with schizophrenia and related illnesses such as schizoaffective disorder. Number 55. Schizophrenia and related disorders such as schizoaffective disorder are not caused by bad behavior or character flaws. Number 56. Just as an individual does not choose to get cancer, Mr. Holmes did not choose to develop his mental illness. Nor did Mr. Holmes choose the nature and content of his delusions. Mr. Holmes still struggles to explain, even years later, why his mission took such irrevocable hold of his mind, telling Dr. Reed, "I don't know why it dominated, but it did." Number 57, it is court-appointed psychiatrist Dr. Jeffrey Metzner's expert opinion that Mr. Holmes' ability to appreciate the wrongfulness of his actions and conform his conduct to the law was significantly impaired by his psychosis, and that Mr. Holmes' mental illness is the sole cause of the shootings. 58, suffering from a mental illness is not a pleasurable or pleasant experience for Mr. Holmes. To the contrary, it was and continues to be very disturbing and distressing to him. Number 59, although he felt compelled to complete his mission, which was the product of his psychotic thinking, committing the shooting itself was not an act that Mr. Holmes enjoyed or took pleasure in. Number 60, other than the events of this case, Mr. Holmes has absolutely no history whatsoever of being cruel or mean to people or animals or of hurting anyone in any way. Number 61, none of Mr. Holmes' neighbors, friends, fellow students, teachers, professors, co-workers, or family identify Mr. Holmes as emotionally reactive, self-important, mean-spirited, attention-seeking, or overly sensitive in the face of rejection. They all testify to that. To the contrary, Mr. Holmes was self-deprecating, calm, sweet, and kind. He was never a poor loser, selfish, or self-centered. He handled rejection and disappointment in his life by withdrawing inward and was a person who avoided the limelight. Number 62. Despite the tragedies of this crime, Mr. Holmes has numerous family, friends, neighbors, teachers, fellow volunteers, church members, and co-workers who love and support him and will continue to do so in the future. Sentencing hearing phase 2, instruction number 5. When you retire to deliberate on your phase 2 sentencing verdicts, each juror must independently determine with respect to each count whether one or more mitigating factors exist. This is an individual decision, not a group decision. The jury need not unanimously agree that mitigating factors exist or that the same mitigating factors exist. A juror may consider a mitigating factor without regard to whether the jury unanimously agrees about its existence. Each juror has the responsibility and authority to decide for himself or herself what constitutes a mitigating fact or circumstance. Each juror must use his or her own personal discretion, life experiences, and reasoned moral judgment in determining for himself or herself what mitigating factors exist. Once a juror has determined that a mitigating factor exists with respect to a count, the juror must give that mitigating factor full or meaningful consideration and effect. The juror may give it any weight that he or she chooses. In other words, the juror may attach whatever significance to a mitigating factor that he or she feels is appropriate, but the juror may not give a mitigating factor that he or she has determined exists no weight by excluding it from his or her deliberations or refusing to give it full or meaningful consideration and effect. Each juror must individually decide what weight each mitigating factor that he or she has determined exists. This too is an individual decision. Each count, each juror must weigh the mitigating factors against the aggravating factors proven by the prosecution beyond a reasonable doubt in phase 1. In weighing the mitigating factors and the aggravating factors on each count, each juror may emphasize any factor more than another, giving each factor as little or as much weight as the juror deems appropriate. Although in phase 1 you are required to unanimously agree on whether at least one of the aggravating factors alleged by the prosecution with respect to each count was proven beyond a reasonable doubt, each of you must now decide individually for yourself what weight, if any, to give to each aggravating factor proven as to each count. Further, the only aggravating factors each of you may individually consider are the aggravating factors that you unanimously beyond a reasonable doubt in phase 1 of the sentencing hearing. You cannot consider any other aggravating factors. The aggravating factors unanimously found to exist beyond a reasonable doubt with respect to each count in phase 1 of the sentencing hearing are: first aggravating factor proven, the defendant unlawfully and intentionally, knowingly, or with universal malice, manifesting extreme indifference to the value of human life generally, killed 2 or more persons during the commission of the same criminal episode. Number 2, second aggravating factor proven, the defendant, in the commission of the offense of murder in the first degree, knowingly created a grave risk of death to another person in addition to the 12 victims of the crimes of murder in the first degree. Number 3, third aggravating factor proven, the defendant committed the offense of murder in the first degree in an especially heinous, cruel, or depraved manner. Number 4, fourth aggravating factor proven, the defendant committed the offense of murder in the first degree while lying in wait or from ambush. The process of individually weighing the mitigating factors each juror has determined exist and the aggravating factors proven by the prosecution beyond a reasonable doubt in phase 1 is not a mere counting process. Your decision should not be mechanical or mathematical. Because the number of factors is not the only criteria you should use in the weighing process and is not determinative, you cannot merely count the number of aggravating factors and the number of mitigating factors with respect to each count and then compare the two totals. Nor should you merely assign arbitrary values to the aggravating factors and the mitigating factors and then subtract one value from the other. Rather, as to each count, the weighing process requires a critical evaluation of the mitigating factors and the aggravating factors so that you can make a reasoned moral judgment as to whether you are individually convinced beyond a reasonable doubt that the mitigating factors do not outweigh the aggravating factors. The exercise of your reasoned moral judgment must be based upon the evidence presented during the proceedings. Sentencing hearing phase 2 instruction number 6. Based upon your earlier verdicts, the defendant has been found guilty of 24 counts of murder in the first degree. As you know, there are 2 guilty verdicts for murder in the first degree with respect to each deceased victim because the prosecution pursued 2 theories of liability as to each deceased victim. murder in the first degree after deliberation, and murder in the first degree extreme indifference. The two guilty verdicts for each deceased victim will eventually merge into a single conviction for murder in the first degree, and based solely on the jury's sentencing verdicts, the defendant will receive a single sentence for that conviction. Accordingly, the defendant will stand convicted of 12 murders in the first degree, and the jury's sentencing verdicts alone will determine the sentences for those crimes. In phase one of the sentencing hearing, you determine that the prosecution proved beyond a reasonable doubt 4 aggravating factors with respect to each count. You must again make 24 separate determinations in phase 2 of the sentencing hearing. This time, as to each of the 24 counts of murder in the first degree, you must decide whether you are unanimously convinced beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase 1 of the sentencing hearing. Sentencing hearing phase 2, instruction number 7. You must treat the defendant as a uniquely individual human being. Further, in reaching your decisions in phase 2 of the sentencing hearing, you must not be influenced by prejudice or bias of any sort against the defendant or the prosecution, and you must not consider any public opinion or community sentiment for or against the defendant or the prosecution. Your decisions in phase 2 of the sentencing hearing may not be the result of mere prejudice, bias, passion, conjecture, or any other irrational or arbitrary emotional response. Sentencing hearing phase 2, instruction number 8. You may consider mercy for the defendant during phase 2 of the sentencing hearing. Your exercise of mercy must be based upon the evidence presented during the proceedings. Sentencing hearing phase 2, instruction number 9. As to each count of murder in the first degree, the sentencing hearing will only continue to phase 3 if every juror is individually convinced beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase 1 of the sentencing hearing. If any juror is not so convinced, then the sentencing hearing will end with respect to that count, and based solely on the jury's phase 2 sentencing verdict, the defendant will be sentenced to life imprisonment without the possibility of parole on that count. Under Colorado law, a sentence of life imprisonment without the possibility of parole means that a person must spend the rest of his natural life in prison without the possibility of ever being paroled. Sentencing hearing phase 2, instruction number 10. Neither party has the burden to prove anything in phase 2 of the sentencing hearing. The fact that a party may have chosen to present evidence in phase 2 of the sentencing hearing does not change this rule. Similarly, the fact that a party may have chosen not to present evidence in phase 2 of the sentencing hearing does not change this rule. In phase 2 of the sentencing hearing, neither party bears the burden to convince you of anything, including with respect to whether mitigation exists, the weight to be given each aggravating factor and each mitigating factor, and the outcome of the weighing process. While neither party has a burden of proof in phase 2 of the sentencing hearing, the degree of certainty that is defined as beyond a reasonable doubt nevertheless applies in this phase of the sentencing hearing. As mentioned earlier, the sentencing hearing will only continue to phase 3 if each juror is individually convinced beyond a reasonable doubt that the mitigating factors do not outweigh the aggravating factors. Thus, in phase 2, the use of the term beyond a reasonable doubt does not refer to a party's burden of proof. It refers to the level of moral certainty that each individual juror is required to have before he or she may conclude that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase 1 of the sentencing hearing. Sentencing hearing phase 2, instruction number 11. Reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of all the evidence or the lack of evidence in the proceedings. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. Sentencing hearing phase 2, instruction number 12. You are instructed that the fact that the prosecution seeks the death penalty in this case is entitled to no weight whatsoever in your decisions in phase 2 of the sentencing hearing. No juror should allow himself or herself to be influenced or prejudiced against the defendant because of the fact that the prosecution seeks the death penalty. Sentencing hearing phase 2 instruction number 13. The court reminds you that the number of witnesses testifying for or against a certain fact during the proceedings does not by itself prove or disprove that fact. Sentencing hearing phase 2 instruction number 14. The court reminds you that you are the sole judges of the credibility of each witness who testified in these proceedings and the weight to be given to each witness's testimony. You should carefully consider all of the testimony given and the circumstances under which each witness has testified. For each witness, consider that person's knowledge, motive, state of mind, demeanor, and manner while testifying. Consider the witness's ability to observe, the strength of that person's memory, and how that person obtained his or her knowledge. Consider any relationship that the witness may have to either side of the case and how each witness might be affected by the verdict. Consider how the testimony of the witness is supported or contradicted by other evidence in the case. You should consider all facts and circumstances shown by the evidence when you evaluate each witness's testimony. You may believe all of the testimony of a witness, part of it, or none of it. Sentencing hearing phase 2 instruction number 15. The court reminds you that you're not bound by the testimony of witnesses who testified as experts. The credibility of an expert's testimony is to be considered as that of any other witness. You may believe all of an expert witness's testimony, part of it, or none of it. The weight that you give the testimony is entirely your decision. Sentencing hearing phase 2 instruction number 16. In reaching your phase 2 sentencing verdicts, you may consider all of the evidence admitted during the proceedings. However, the evidence admitted during phase 2 of the sentencing hearing for the limited purpose of determining the existence or absence of any mitigating factor may only be considered for that limited purpose. Such evidence may not be considered as evidence of aggravation or for any other purpose. Additionally, the evidence admitted during the trial for the limited purpose of considering the issues raised by the defendant's plea of not guilty by reason of insanity may only be considered now for a different limited purpose, for the limited purpose of determining the existence or absence of any mitigating factor. You cannot consider such evidence as evidence of aggravation or for any other purpose. Sentencing hearing phase 2 instruction number 17. Every person charged with a crime or convicted of murder in the first degree has the constitutional right not to testify. The defendant did not testify during the first trial or during phase 1 or phase 2 of the sentencing hearing, as was his right. You shall not draw any negative inference from his choice as to the punishment to be imposed or any other matter. You shall not allow his choice to prejudice him in any way. His decision not to testify cannot be used as a reason to support or impose the death penalty. You must not discuss the defendant's choice not to testify or permit it to enter into your phase 2 deliberations in any way. Sentencing hearing phase 2 instruction number 18. You were permitted to submit written questions to witnesses during the trial. If a particular question was not asked, do not guess why the question was not asked or what the answer might have been. My decision not to ask a question submitted by a juror was not a reflection on the person asking it, and you should not attach any significance to the failure to ask a question. By making legal rulings on the admissibility of questions, I did not intend to suggest or express any opinion about the question. My decision whether or not to allow a question was based on the applicable rules of evidence and other rules of law, and not on the facts of this particular case. It is my responsibility to assure that all parties receive a fair trial according to the law and the rules of evidence. The fact that certain questions were not asked must not affect your consideration of the evidence in any way. Do not give greater weight to questions or answers to questions that were submitted by yourself or your fellow jurors. In making your decisions, you must consider all the evidence that has been presented. Sentencing hearing phase 2 instruction number 19. You've been allowed to take notes. Whether or not you took notes, you should rely on your memory as much as possible. The notes that you took are to refresh your own memory. You should not give additional weight to the comments of any juror based upon the quantity or quality of his or her note-taking. Sentencing hearing phase 2, instruction number 20. Once you begin your deliberations, if you have a question, your foreperson should write it on a piece of paper, sign it, and give it to one of the bailiffs who will bring it to me. The court will then determine the appropriate way to answer the question. However, there may be some questions that under the law the court is not permitted to answer. Please do not speculate about what the answer to your question might have been or why the court is not able to answer a particular question. Finally, please be sure to keep the original question and response. Do not destroy them, as they are part of the official record in this case and must be returned to me when you return the instructions and verdict forms at the end of the case. Sentencing hearing phase 2, instruction number 21. There's no requirement that you explain or justify to your fellow jurors why you reached a particular determination, whether with respect to the existence of mitigating factors, the weight assigned to each aggravating factor and each mitigating factor, and the weighing process. Nor are you required to agree with the determinations, opinions, feelings, or thoughts of other jurors. Nevertheless, it is your duty as jurors to consult with one another and to deliberate. Each of you must individually decide the issues for yourself after discussion and consideration of the evidence presented in the proceedings and these instructions of law with your fellow jurors. Sentencing hearing phase 2, instruction number 22. Following the attorney's closing arguments at the end of phase 2 of the sentencing hearing, the bailiffs will escort you to the jury room so that you may deliberate. Your foreperson will preside over your deliberations. You will be given 24 separate phase 2 sentencing verdict forms, one for each count of murder in the first degree. Each verdict form has 2 sections, 1 and 2. That's Roman numeral 1 and 2. Your phase 2 sentencing verdict on each count must be reflected in section 1 or section 2 of the verdict form for that count. You must make 24 separate determinations. As to each count, you must indicate whether or not every juror is convinced beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase 1 of the sentencing hearing. The verdict form shall be completed in the manner that reflects your decisions. If, with respect to a count, the jury unanimously finds beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase 1 of the sentencing hearing, the foreperson shall sign on the designated line in section 1, and the rest of the jurors shall sign on the other lines in section 1. In that event, the sentencing hearing will continue to phase 3 on that count. If, with respect to a count, one or more jurors do not so find, the foreperson should sign on the designated line in section 2. In that event, the sentencing hearing will end with respect to that count, and based solely on the jury's phase 2 sentencing verdict, the defendant will be sentenced to life imprisonment without the possibility of parole on that count. Only one phase 2 sentencing verdict shall be returned signed on each verdict form. Therefore, only one section, section 1 or section 2, shall be completed on each verdict form. The phase 2 sentencing verdict forms and these instructions shall remain in the possession of your foreperson until I call for them in open court. Upon reaching your phase 2 sentencing verdicts, you will inform the bailiffs, who in turn will notify me, and you will remain in your jury room until called into the courtroom. I will now read a sample phase 2 sentencing verdict form. You must not draw any inferences based on the verdict form I have selected to read to you. Does everybody have the sample verdict form? All right, great. Everyone's saying yes and nodding their head. Phase 2 sentencing verdict form. Count 1, murder in the first degree after deliberation. Jonathan Blanc. Phase 2 sentencing verdict question. Does the jury unanimously find beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase 1 of the sentencing hearing? Roman numeral 1 and the single asterisk reads as follows. Answer to phase 2 sentencing verdict question, yes. Roman numeral 2 and the double asterisk reads as follows. Answer to phase 2 sentencing verdict question, no. And there is a space for the foreperson to sign in section 1, as well as 11 other lines for the other jurors to sign in that section. If the jury's answer is yes, there is a space for the foreperson to sign in Section 2, if the jury's answer is no. On the next page, the single asterisk reads as follows. If the answer to the Phase 2 sentencing verdict question is yes, the foreperson shall sign on the designated line in Section 1, and the rest of the jurors shall sign on the other lines in Section 1. In that event, the sentencing hearing will continue to Phase 3 on this count. Only one section, Section 1 or Section 2, shall be completed. The double asterisk reads as follows. If the answer to the Phase 2 sentencing verdict question is no, the foreperson shall sign on the designated line in Section 2. In that event, the sentencing hearing will end with respect to this count, and based solely on the jury's Phase 2 sentencing verdict, the defendant will be sentenced to life imprisonment without the possibility of parole on this count. Only one section, Section 1 or Section 2, shall be completed. All right, folks, with that, then, we're going to go ahead and take a break. Please leave your instructions in the sample verdict form here in the courtroom on your chairs. Let's take about 20 minutes, maybe a little longer than that, 20 to 25 minutes. Please make sure you comply with all my advisements during the break. They all apply. So do not have any discussions about the case. I know that I just went through the instructions and the sample verdict form. You cannot talk to each other yet about any of that. You cannot start deliberating until I tell you that you can start deliberating. Does everyone understand that? Yes, okay. And if we have the exhibits already in the jury room, no, not yet. Okay, so you can go in jury room 201 then. Okay, thank you. Please be seated, everyone. The record should reflect that the jury has exited the courtroom now. I have a question for counsel with respect to instruction number 16, the one that talks about the limiting purpose for which certain evidence has been admitted. It does not address other evidence admitted for a limited purpose. As you know, this issue came up during the Phase 2 sentencing hearing, and I reminded the jury about that, and I said that certain statements, for example, were introduced only to place the defendant's statements in context. And I said to them that to the extent that those statements were admitted for a limited purpose, in other words, the statements not made by the defendant were admitted for a limited purpose, that the jury can only consider them for that limited purpose now. So I explained that to them, and I think in instruction number 1, I also say in general that to the extent that any evidence was admitted throughout the proceedings for a limited purpose, the jury can only consider it for that limited purpose. But I wanted to point that out to counsel. I don't think it's necessary to make any change on that or to add anything, but I wanted to point it out. Are the people asking me to take any action?
No, Judge.
Is the defense, Ms. Brady?
No, sir.
Okay, great. All right, is there anything else that we need to talk about then before we take a break? On behalf of the people, Mr. Orman or Mr. Brockler? Ms. Brady, on your behalf?
Your Honor, just very briefly, and I haven't even told Mr. Brockler this, but I'm just going to make 3 objections, and the court has already ruled on these in the instructions, but I do just want to object to them being on a slide. In Mr. Brockler's final PowerPoint presentation, he has a slide that states that mercy must be based upon evidence presented. I know Ms. Nelson litigated that with the court, and the court made its ruling, but I did want to renew our objection on that. And also there's a slide that says instruction number 4, defendant's theory of mitigation, and I believe Ms. Nelson has objected to that and litigated that, but we do renew that objection.
What was the third one?
And the third one is a slide that says mitigating factors that exist do not outweigh aggravating factors. And I would object to sort of the proclamation type slide that is. It's not telling them that that is what they're to determine or the task before them, but sort of a proclamation by the prosecution that that is the case. And so I would object to that being on a slide.
Okay, thank you. In terms of the first two arguments, I have addressed those issues, and I understand that Ms. Brady is just making a record because some of the instructions are included in the prosecution's PowerPoint presentation, although frankly, I think the defense has preserved the issue by objecting to the instructions. I don't think that any additional record was necessary, but in any event, I stand by my rulings as to those two issues. As to the third issue, Mr. Brockler, do you want to address that?
Yes, sir. Clearly, a slide in and of itself doesn't tell the story. It's to facilitate a conversation about the law. And certainly, if I were to stand up and to suggest to the jury that the mitigation facts as a matter of law don't outweigh the aggravators, I would expect Ms. Brady to stand up and very vociferously object. That's not the purpose of that slide. It's to allow me to have a conversation about what the weighing process is about.
Okay. I don't have the slide in front of me, and I haven't heard in what context he is going to refer to it or how it's going to be used. So, Ms. Brady, if you feel you need to object when he brings it up, you can object at that point. If he's just highlighting part of an instruction, then I don't think that's improper. So to the extent that the objection is that he's highlighting only a portion of an instruction, the objection is overruled as long as it does not convey a meaning that is inconsistent with the instructions. So as long as it's not taken out of context or that it will mislead the jury in some way, I don't have any concerns with it.
And just so the record's complete, I will provide the court with a disc with my slides that I'm going to use, and I would ask that Mr. Brockler do the same.
All right, Mr. Brockler, any objection to that? All right, and Ms. Brady, just to make sure, you're not arguing that he's taking that language out of context or misleading the jury by using that language. Is that correct?
It's not that it's misleading. It's that it's an argument on a slide. And so the entire slide, and I can show it to the court if the court wants to see it, but it says mitigating factors that exist do not outweigh aggravating factors. And so it's not stating the law, it's just stating their position on a slide. And I understand that this is argument and that they can argue that, but putting a slide up on a big screen TV that says mitigating factors do not outweigh aggravators, I think is improper. And so that's the basis of my objection.
All right, Mr. Brockler, this is your argument. Is that correct?
Yes, sir.
All right, as long as you make it clear that it's your argument, that it's not the law, and there's no confusion at all that this is part of the instructions, then I think it's appropriate. It's argument. Both sides are going to make argument. As long as the jury's not misled, then it should be okay. All right, let's go ahead and take our break at this time. The court will be in recess. Thank you.